This is Checkpoint and I'm Lisa Owen. Former Southern Response customers are questioning whether the state insurer should be investigated under the Crimes Act for deceiving its customers. It comes after a High Court ruling last week found a Southern Response practice of writing up two separate costings for home repairs and only offering the customer the cheaper one was deceptive and misleading. Christchurch couple Mark Gilmour and Althea Kallas say they have also been shortchanged by $200,000. After ministerial intervention, they had a face-to-face meeting with CEO Anthony Honeybone last year, but he dismissed their claims. And now the couple wants an inquiry into Southern Response and an investigation into whether the company has breached the Crimes and Fair Trading Acts. Logan Church explains.
Mark Gilmour and Althea Kallas have an all-too-familiar story of earthquake damage and battling to get their Littleton home over cap and away from EQC. They were hoping to fix their earthquake-damaged home on the hill, but in 2014 a large landslide dashed those hopes and made their home uninhabitable.
We were phoned on the 14th of May 2014 and told what the settlement amount was. So on the 16th, we went into Southern Response and we signed a settlement and discharge agreement for $354,000. There wasn't any discussion really with Southern Response about how they arrived at that figure. We simply trusted them that they would provide enough money for us to rebuild our house.
Trust. That word came up many times in our interview. Mark and Althea were paid out $354,000 and moved away from Christchurch. But then,
in July 16, I applied under the OIA Act for the full Southern Response file. And I did that after reading of someone else that had done the same thing and found these two DRAs. So we did that and we found the two DRAs. And naturally, we were a bit upset.
One detailed repair analysis dated the 29th of April 2014 was for $540,000, with contingencies taking it up to $701,000. The second, dated a week later, the 7th of May 2014, was costed at $354,000, with contingencies bringing that up to $478,000. On the figures including the contingencies, that's a difference of $223,000. To put that in perspective,
the cost per square metre went down 40% to $1,533 a square metre. Well, as anyone knows, you can barely build a dog kennel on the hills for that amount per square metre. But to think you can rebuild a house for $1,533, it's just impossible.
As you can imagine, this raised huge questions. What happened in the week between the two DRAs that saw a drop of almost $250,000? Why? Who authorised it? And why wasn't either DRA shown to Mark and Althea when they settled? The couple believed they had been misled and deceived and wanted answers. After trying to get those answers out of Southern Response, they wrote to then Minister Responsible Megan Woods last year, who arranged a face-to-face meeting with them and Southern Response Chief Executive Anthony Honeybone.
Well, the meeting took place at the Southern Response offices.
We passed through security. They knew we were coming. We gave them our names and we were let through.
Mr. Honeybone was accompanied by
one other person, like senior project manager.
I can't remember his name
like
at the
that.
moment. And he listened to our story.
He listened politely. He sat there.
We had given that in writing to him, so he was fully aware of the situation. You know, thanks to the minister, we did get an interview with Mr. Honeybone, but it was a waste of time.
The couple says the crux of the issue comes down to one simple question.
The first question that we asked is how they managed to reduce this large figure to a smaller figure. And they said they got a new independent builder to firm the costs. It turned out this was not true. They never got a new independent builder.
3 weeks after the meeting, Mr. Honeybone wrote back. Here is part of his 3-page letter.
You have requested that Southern Response reopen your settled claim and pay you the difference between your settlement amount and estimated repair costs in the other DRA. Given the evidence on the claim file and the understanding of the process outlined above, I have found no evidence to support your contention that there was anything deliberate or underhand about how the final repair price on which you settled was reached. To be clear, Southern Response will not reopen your settled claim nor pay you the difference you request. After meeting with you and hearing your views on Southern Response, I know that you may feel that my conclusion was inevitable.
A Supreme Court judgment in 2015 slammed the double DRAs. The Dodds High Court ruling last week also slammed the double DRAs, and that's what prompted Mark and Althea to come to Checkpoint.
In my opinion, what you look at, there's only two explanations or a combination, immoral or incompetent. You don't get these results unless you're either immoral or incompetent, and that's what our perspective is anyway.
That $223,000 difference has come at a huge cost.
But it was just such a stressful time. If we'd have been paid out what we believe is the correct amount, it would have changed our life completely.
Yeah, our decisions would have been completely different. We've had 4 houses in 5 years. If we'd been paid out properly, we could have settled probably just once and carried on living normally instead of feeling completely like what the heck's going on.
And the couple is calling for an inquiry into the conduct and behaviour of Southern Response.
I absolutely do think there's got to be a public inquiry because we are only one of thousands. Just one. There's got to be a lot of other people out there that have been basically shafted by Southern Response.
But Mark, a former police officer, is also wondering if a more serious step needs to be taken.
Section 240 of the Crimes Act relates to deceitful behaviour. And my view was that there could be a case to answer not only for a breach of the Fair Trading Act for deceitful conduct, but actually a breach of Section 240 of the Crimes Act, which is a much more serious standard of deceitful conduct.
The ramifications of the double DRAs could be huge. Southern Response is owned by the government, but it's ultimately answerable to the taxpayer. Lawyers estimate the double DRA policy could cost Southern Response and the government $300 million. And you, the taxpayer, would have to pay that if a current class action on this very issue is successful. So that brings us back to Southern Response management and our hunt for its chief executive, Anthony Honeybone. Where is he? In Christchurch for Checkpoint, Logan Church.